Justice Shakhtar has practiced in the Supreme Court of India, High Court of Delhi, and other high courts across India, tax tribunals, and the Company Law Board, amongst numerous others. Sir has vast experience in civil litigation, constitutional law, with special emphasis on commercial litigation, corporation, and taxation laws. Sir was appointed as a counsel for the Union of India in March 1995 by the Government of India with respect to its cases in the High Court of Delhi. Sir was also appointed as counsel by the Office of the Comptroller and Auditor General to defend IAN AD matters before the Central Administrative Tribunal. Justice Shakhtar was appointed on the senior panel of the Union of India in the Delhi High Court in 2004. Sir was appointed to the Union of India panel in the Supreme Court of India in 2005. Sir was also later appointed as an additional judge in Delhi High Court in 2008 and later went on to become a permanent judge in 2011. Ladies and gentlemen, please join me in welcoming Honorable Justice Shakhtar.
Good evening, ladies and gentlemen. I know 6 o'clock is not the best time, it's actually 5:30. It will be convening to hear speeches from judges who, as I have always said, are a boring lot when it comes to public speaking, but I'll make an attempt. And the burden is actually to be borne by my Professor Douglas. It's an interesting concept which Shashank has come up with, which is having these talks. It's almost like what we have, you would have seen that on the YouTube, it's the TED Talks. So I was joking with Doug just before the session started that, you're going to be our first TED Talk speaker in that sense. But thank you very much for calling me here. Chief Justice Lahoti, Justice K.K. Lahoti, Gupta, Mr. Tejas, Professor Jones, and all other friends of the dais. 20 years ago, when I started in the profession as a young and enthusiastic lawyer, I was attempting to press a special petition in the Supreme Court. The answer that I got from the bench then was arbitrate and litigate. And with that one sentence, my SLP was dismissed. I was actually forlorn and had a hang-dog expression. But then I realized that over the years, why the court or the bench reacted the way it did. Because 10 years on the bench has taught me one thing, which is that to sort of deal with this mountain of cases that we have before us, the only way that we can possibly reach justice to the litigants is by adopting alternate dispute resolution methods. So ADR is, and I think will continue to be, your mantra for meeting with a challenge which is so huge in India that one sort of just doesn't know how to go about it if you didn't have something like this. So ADR, while it is there, it has evolved, and one of the ways that it has evolved is by using experts to deal with what are increasing very complex matters. Now, experts, as I look at it, and Professor Douglas Jones will tell us more, can be in the form of witnesses, or you can have actually expert arbitrators. Legislations all over the world have provisions for experts. In fact, most of you would be aware that even in the 1996 Act, which is based on the United Nations model law, you have Section 26, which gives you the ability to have an expert present himself before an arbitrary tribunal. So either parties will bring experts, or the tribunal itself will appoint an expert and have him give his testimony before the tribunal. The difficulty with having an expert witness is that his role is limited, in the sense if he is a witness or an expert presented by one party or the other, he would say what ordinarily would be believed to be one side of the picture, and then you will have another expert. So you have another concept which is known as witness conferencing, where I was told, which is something that I have not seen in India, but I was told that witnesses, expert witnesses, so to say, are confronted, and while they confront, the tribunal gets a sense as to what is the way forward. So in India, my experience has taught me that parties are trying to evolve further by actually having provisions in the contract, and you have a lot of these civil contracts in courts, and which are also before tribunal, where they have evolved a strategy whereby you have an expert and still you can go to an arbitral tribunal, which is in the contract. You have a two-step methodology where you have what is known as a dispute resolution board, or a panel of experts. So if you have a grievance with the employer, then the contractor would take his grievance to a dispute resolution board or to a panel of experts. If there is unanimity, then the matter ends there. If there is no unanimity, then he has the ability of carrying the matter further to the dispute resolution board. Resultantly, what happens is that there is party autonomy, in the sense you go to experts, and then thereafter, if you're not happy, you go to an arbitral tribunal. But the best way forward, which parties have over the years discovered, according to me, is really to have experts sit as arbitrators. Now, when experts sit as arbitrators, if it's an institutional arbitration, then I think it's the best outcome, because none of the parties really in that sense would have control over who is the arbitrator. Even if it is not an institutional arbitration, or it's an ad hoc arbitration, or there is a way out where one of the parties can appoint an expert. He, in a sense, will bring his domain expertise into the adjudication process, and therefore help speed up the adjudication process. The danger, according to me, which is something that we need to look at, is that when you have an expert, and that's a tendency which is easy to get tempted by, is when you know something about a subject, you tend to bring in your own knowledge into the adjudicatory arena, which is, if I've taken an example, if I know something about accounts, I'm a chartered accountant, tomorrow I retire as a judge and I become part of an arbitral tribunal. It's very tempting at that time to look at the evidence as an accountant, and you at times shed the role of an arbitrator, which then leads to a situation where you are actually at times discounting the evidence that is placed before you by the parties. You are actually the expert for A or the B party, whoever you think has a case in the matter. And it is when your expertise is undisclosed to the party doesn't get to assail that, or doesn't get a fair opportunity of dealing with what you have in mind vis-a-vis the material put before the tribunal. So, sans this area, which according to me is a rubric that is drawn where you have experts sitting as arbitrators, according to me it's a win-win situation, which is something that arbitral tribunals should take forward. And actually I think the time has come that you would need an expert, because matters are complex, where you have contracts worth 4,000 and 5,000 crores, civil contracts or other contracts, or you have charter party contracts, or shipping contracts, or disputes. So therefore, to my mind, having experts is something that litigators, the disputants, should examine. Now, whether it is a good idea or it is something which has its pitfalls is something that I'm sure Professor Doug would tell us. And since he's the speaker for the day, I wouldn't like to take too much of your time on that issue and leave the floor to Professor Doug to do the rest of the talk. Thank you so much.
Good evening, honourable sitting and retired judges, senior arbitration colleagues from the arbitration community, friends and colleagues. It is a singular honour to have the opportunity of delivering the first of these DREx talks. It is a fascinating initiative, typical, may I say, of the level of enthusiasm and innovation which one finds nowadays in India in the area of dispute resolution and international arbitration. India has for many years been regarded, sadly, as a pariah within the international arbitral community due to the approach now abandoned by the Indian courts to international arbitration. But for a number of years now, there has been developing in India a level of enthusiasm and innovation in the international arbitration space, which will provide huge opportunities for India and for Indian lawyers around the world to take their rightful place in the international arbitral community. And this initiative of DREx is typical of the steps being taken in the Indian space of international arbitration to put the footprint which India deserves on the area of international arbitration. So my heartiest congratulations to those whose initiative this is, and I wish it well and hope that in this initial talk we will have something of value to contribute to the debate internationally led by this initiative. So, this evening I want to talk about 4 issues in the context of experts in international arbitration. I'd like to commence by looking at the historical differences from domestic legal practice which informs international arbitration in this area, the civil and the common law approaches. To describe the implications of those approaches for international arbitration, to look at how international arbitration guidelines are informing the use of experts, and then to discuss some proactive case management strategies that can contribute effectively, from my experience, to the use of experts. And the topic that I chose to speak about this evening, that of experts in international arbitration, is, I think, one of the areas where there is huge room for improvement in India. I think the use of experts in international arbitration in India, in my experience, is relatively undeveloped. And the opportunities that you have in India to learn from and take advantage of the processes which we are finding effective in other parts of the world is enormous. And therefore I thought that this topic would perhaps contribute significantly to the development of an aspect of international arbitration, which in my humble opinion is a very important aspect of ensuring that international commercial arbitration is conducted effectively and economically. But it's necessary to look at a little bit of history. All of the advocates in international arbitration and all of the arbitrators who preside in international arbitrations come from particular domestic backgrounds. Each of us has learnt our law in a particular jurisdiction, and we have become familiar with the way in which procedure domestically works for us as part of our original experience. International arbitration, of course, brings to the table of dispute resolution counsel and arbitrators with diverse backgrounds. And the process of how to successfully conduct an international arbitration has involved an evolution of combining domestic traditions which the players themselves bring to the process. So that what we have in international arbitration is a developing amalgam of procedures which are thought to usefully inform the process of international arbitration, choosing the best from the various domestic regimes from which the practitioners come. And of course, there are two largely different systems of procedure found domestically around the world. And I don't, by this, intend to ignore the Islamic tradition. But the amalgam of which I speak is largely one of dealing with the differences of approach to dispute resolution in the civil law world and in the common law world. In the context of experts, domestic civil law procedure depends largely upon the tribunal appointing its own expert, who will report to the court his or her findings on the particular area of expertise that requires inquiry. The approach of the civil law judges is an inquisitorial one, where the process is largely led by the tribunal. And there is, of course, differences between civil law jurisdictions, but it's fair to say that that is a dominant aspect of the way in which expertise is obtained by civil law courts. On the other hand, in the common law world, the appointment by tribunals domestically of experts has been a rare event. Experts are normally deployed by advocates on behalf of their clients as party-appointed experts. And so within the civil law, common law divide, one sees a complete difference of approach to the use of expertise to inform tribunals. It's fair to say that the common law world has had real difficulty over the years with party-appointed experts being hired guns advocating the interest of the party whose lawyers have appointed them. And so one sees in a whole range of areas, including medical negligence and other areas, whole practices developed by experts who, say in the medical area, have long since abandoned doing any medicine and whose whole income is dependent upon giving evidence in courts. And the common law courts have said in a number of jurisdictions, including Australia and England and many others, that this is a wholly unsatisfactory way to inform the tribunal domestically of the real issues, because it's just a means of advocacy. And this is writ large in the context of US litigation, because as many of you will know, there is an absolute right to trial by jury in civil law proceedings in the US. And thus, experts are deployed in major commercial litigation tried by juries as an adjunct to the advocacy of counsel. They are essentially a way of explaining simply the point of view of the particular party who engages that expert. So the problem of the hired gun, writ large across the common law world, domestically, is emphasised even more in the US because of the jury system. So, with those competing approaches to the use of expertise, where has international arbitration landed? Well, it's fair to say it hasn't yet landed. It is an evolving picture to which all of you can contribute with your ideas and innovation in procedure. But put very simply, what has happened is that the civil law lawyers engaged in international arbitration have embraced with enthusiasm the concept of the party-appointed expert and have no history of all of the difficulties which the common law world has faced domestically over the years with the hired gun concept. So, one sees in international commercial arbitration nowadays very few tribunal-appointed experts, although the attempt for an amalgam of procedure in this area, emphasised when it was first developed by the International Bar Association, detailed rules for the appointment of tribunal-appointed experts seeking to respect and take account of the civil law tradition. I've sat in quite a few international commercial arbitrations now, well over 100. And only in one case did I ever get to the point of appointing a tribunal expert. And that was it, where there was a dispute in a joint venture company breakup about the preparation of accounts. And I directed in that case that there be one set of accounts prepared for the purposes of the dispute by a tribunal accountant who I would appoint. I never found out how it worked because the parties settled at that point. I think motivated by the fact that they knew games could not be played in relation to the accounts, which were a critical aspect of that dispute. So, the issue in international commercial arbitration from a practical perspective is how to cope with party-appointed experts. And although theoretically possible, tribunal-appointed experts are not the real issue. And that's why I wanted to address this topic tonight. Now, in the context of party-appointed experts, one sees some useful soft law guidance from two sources. The International Bar Association has developed rules on the taking of evidence in international commercial arbitration. One of the most influential pieces of work done by the profession to try and reach an amalgam between the various domestic traditions of the dispute resolution community that came together in international arbitration. And in the latest iteration of the IBA rules on the taking of evidence, there is an explicit recognition of the need for party-appointed experts to have their independence preserved and taken advantage of. In a more detailed context, the Chartered Institute of Arbitrators has published a protocol for the use of party-appointed expert witnesses in international arbitration, and that is a much more detailed and exceptionally useful reference starting point for the use of experts. However, I said earlier, and I repeat, obtaining value for the parties and for the tribunal through the use of party-appointed experts is a work in progress. And it's only through proactive case management that, in my view, there can be a success achieved in the interests of the process and the parties in this context. So I intend to look at strategies in the context of arbitrators proactively case managing expert evidence in three areas. How to manage the expert evidence from the outset, streamlining the exchange of expert evidence, and providing to the tribunal assistance from the experts in the finalisation of an award and the calculation of damages. So coming to the first of these topics, managing the expert evidence. I mentioned when I was discussing the domestic traditions of the use of expert evidence in the common law world that courts have been struggling for quite some time to find a way of reducing the hired gun syndrome. And English and Australian courts, for example, have developed court rules which try to emphasise the need for party-appointed experts to be independent and act in the interests of the tribunal rather than the parties who pay them. But those innovations have sadly failed to solve the problem. And there is a need to extend beyond the rules which one sees in the commercial courts of England, Australia and other jurisdictions, the process of dealing with party-appointed experts. And there is a process which is foreshadowed but not spelt out in detail in the Chartered Institute of Arbitrators guidelines that I've mentioned, the protocol, which I find an exceptionally useful way of dealing with this question. And it involves the tribunal getting hands-on with the experts at a very early stage of the procedure. Firstly, identifying very early on in the case management process what areas of expertise it is appropriate to have deployed for the assistance of the tribunal. What areas of the case, what issues require expert evidence. Then to have the parties identify, once that has been established, who the experts in each area of expertise are going to be, in case there is fundamental objection, which should be taken at a very early stage, as to whether the individuals in question are appropriate or not. either because of conflict or lack of expertise or the like. Secondly, once that has been done, areas of expertise and experts established and identified, there is then created by the tribunal, either with the agreement of the parties or by determination by the tribunal, of the questions to be asked of the experts in each area of discipline. So often, in international arbitration, parties will appoint their experts, tell them what they want them to opine upon, and produce for the tribunal a report from their expert. The other side will do the same. And are they answering the same questions? No. They're answering entirely different questions which happen to suit the case theory of the lawyers who've appointed them. Now that is the most classic way to ensure that ships pass in the night. They don't stand any chance, as some US Navy ships do, of collision. They pass well apart. And the tribunal is faced with two competing case theories from experts who have not engaged at all. To avoid that, it is therefore critical, before the experts start work, to identify what questions each will answer within each area of discipline. Often, parties can't agree on that, in which event I find it really useful to have a case management conference with the parties and their experts and say to the experts, you know what this case is about. What questions do you think you should be asked? Interestingly, I've got a case in London next week. It goes for a whole month, which for an international arbitration is a long hearing, involving the construction of a nuclear power station. Applying this process to that case, quite some time ago, I had a case management conference with my other tribunal members, the parties and the experts, for 2 days, at which one of the objectives was to settle what questions the experts were going to be asked. Now, the parties misunderstood the tribunal, and the experts arrived delivering to the tribunal a list of questions they thought they should be asked. And it was an amazing experience, because the experts had actually thought about the issues within each of the areas of discipline. There are 7 separate areas of expert discipline in this case. And they had draft questions for themselves. We involved the parties, of course, and counsel, but we didn't let anyone leave that 2-day case management conference until there was a list of questions with which experts were happy and which the council were happy. And as a consequence, we have a pretty significant dispute able to be managed effectively by getting a contribution from each of the experts in the disciplines answering the same questions. The second thing that absolutely must be done, but which is obvious when you think about it, but often not done, is that the experts need to be given the same material. So if there are 2 experts on a particular issue, often again one sees each party giving their expert what they want their expert to see. And so when you come to cross-examination at a hearing and one expert is asked, have you seen this document? They say, no, I haven't seen that document. Well, what would you say if you saw it? Well, I might have a different opinion. A complete waste of everyone's time. So I insist on there being a common data set which the experts have access to, and if an expert wants material that is not available, they are entitled through counsel to ask to see the material so that there will be available to the experts what each of them consider is necessary for them to express a genuine opinion. Then, it is important to ensure that the experts understand the assumptions which each is being asked to make for the purpose of their report. So often, again, there are different assumptions put by parties to experts, and those assumptions are not given to the other expert to assist. So the next process is exchanging expert evidence. The more traditional approach is that as part of an exchange of parties' cases, there will be individual expert reports provided by each party, written by the expert, without the benefit of any discussion with the other expert in the area of discipline. Now, human nature being what it is, once someone, an expert in this case, has committed to writing an opinion on something, they are naturally reluctant to change their mind. Sometimes they do, but it's just a basic principle of human psychology. So what I do, and which I think is absolutely essential, is that before the experts do anything, to commit anything to writing, they talk to each other, having had identified what it is that they're asked to opine upon. So they have the questions, they have a common data set, and then they talk to each other without prejudice, if you will, in the sense that their discussions and drafts that they might exchange between each other are not able at any time to be seen by the tribunal and used against the individual. And the first thing that the experts do is not produce their own individual reports, but they produce a common report after discussion which says, in respect of these questions we are asked to opine upon, we agree on these issues, but we disagree on these other issues. And they identify why they agree and why they disagree. Only after they've done that do they then prepare individual reports which deal only with their areas of disagreement. Now, it is often necessary, as this process develops, for the tribunal to encourage the experts to work hard at making sure that they leave no stone unturned to producing common positions. Despite the value of witness conferencing at the end of the procedural stages of an arbitration, hot tubbing is a waste of time if you have not insisted as a tribunal on the experts doing a lot of work beforehand of the sort that I described. But when it does come to the evidentiary hearing, there is enormous value in having the experts sitting together as their opinions are explored, usually by cross-examination and then by tribunal questions, but sometimes, at the request of the parties, by tribunal questions in the first instance. And I must say that there is one category of expert with whom I have inevitable difficulty, and they are legal experts. They are the worst. Particularly eminent retired judges who are paid to express views on behalf of parties and who disappear into the corner of their party, the party's corner, and never come out. I'm just fresh from Hong Kong last night, involving experts on Korean law whose value to the tribunal, putting it very generously, has been marginal indeed, and the amount of time taken by them has been huge. So I haven't had a great deal of value in this whole process with legal experts, and I'd have to admit that outside that area, I think the whole process leading up to hot tubbing and hot tubbing is of enormous value. Now, this process of proactive case management is critical in order to have the experts really assist the tribunal. It is so often the case in the context of the ships having passed in the night that the only choice a tribunal has is to believe one expert or the other. And that is a wholly inefficient and unsatisfactory way to capture the expertise represented. So what I like to do, and which is now broadly accepted in the arbitrations that I do, is to say to the parties and the experts, okay, we understand now what our choices are. We understand that from those choices will come different financial outcomes. Please let us have a relational model from which we can pick the decisions we need to make, and that model will produce an outcome, including, at the bottom of the model, the competing contentions between the parties on interest. Some cases are too complex for any model to be able to simply give you a tick or a cross on each of your options and fall out with a dollar figure. But even if they are simple enough to do that, one always needs to be sure that one's running the model properly. And of course, the technology associated with models, probably familiar to those of you who are here tonight from a younger generation than mine. You probably aren't as terrified of models as I am. But when I'm running a model, I like to have it checked. So, at the very least, I say to the parties and the experts, please agree that the tribunal may confidentially have the assistance of the experts to ensure they run the model correctly. Or, if it's too expensive to build the model, because there's just so much work, please give us the experts on a confidential basis so that we can tell them what our decisions of principle are, and they can agree on the financial outcome of those decisions of principle. And that has worked extremely well from my perspective and ensured, hopefully, that the final mathematical calculation of the award is as accurate as it can be. So, in conclusion, fundamental principle for party-appointed experts must be that their duty is to assist the tribunal. A difficult thing to bring into practice when they're paid by one party and not by the tribunal, but a critical element of achieving a satisfactory outcome. They need to be independent, although clearly their relationship with council and their party is important. And the best practice management of the process of party-appointed experts is evolving. You have an opportunity here in India to contribute to it. Most of the experts who I have worked with have welcomed the opportunity to add real value to the process, and I'm sure that you will find it thus in India as well.
Given terms of the global best practices that could be adopted in India with respect to arbitration, which we could learn from. That's it. Thank you.
My impression is that the use of experts, financial experts and other areas of expertise, for instance in the construction context, delay, disruption and quantum, is evolving. It is not as well developed as it is in other parts of the world. And I think that there could be value in some continuing engagement between council and experts on how this process could be developed. There is, of course, always, particularly in the common law context, huge resistance from council to the loss of control that comes from having their expert put before a tribunal without them knowing exactly what's going to happen. And that fear of loss of control by an advocate of their expert is something which needs to be dealt with sensitively. I am proud, though, that in a quite large dispute involving an offshore oil and gas processing facility heard in New York, with two firms of New York attorneys on either side, coming as they did from the jury system, we actually managed to achieve a process similar to what I described, and have counsel at the end say, oh, that was really quite effective. You can't impose this in arbitration on counsel or parties. They have to recognise the value of the process. So it is an educational process, and it's really important for tribunals to understand what the options are and to lead and guide the parties towards a solution which will be effective. Ultimately, though, of course, in arbitration, the arbitrators are the servants of the parties. And if there is implacable disagreement on a process which is sensible, then that's where it lies. I personally have been disappointed in gas pricing dispute arbitrations, of which I do a number, that International Arbitration Council simply refuse to allow their experts to talk to each other. And the first time they see each other is at the hearing. I do insist on a hot tub, but the value is lost in that process, but one is bound in that instance by the parties' agreement. So, long answer to a difficult question. It's an evolutionary and educational process. Understand the tools, have counsel realise that there is value for them and for their clients in the process, and listen to what the experts say, because they experience this and understand what value they can add if they're allowed to work cooperatively together.
Would you recommend using experts other than the stage of evidence? For instance, in technical matter, would you recommend using experts at the stage of framing of issues? It is something which we do not have in courts. Because we do use expert evidence in courts, but we do not use experts at the stage of framing of issues. Something as innovative as at the stage of case management conference. Because when we do a case management conference in court, we do not use experts.
My answer has got to be yes, but it depends on how the actual case theory is being developed by counsel. I find in international arbitration that the experts have been part of the case theory from way back, and therefore they know the case or the issues reasonably well, so that even before the pleadings, if you have pleadings, or even before the memorials are developed, if you have a case management conference with the experts present, they actually do assist in framing the issues. The issues are ultimately those of counsel, of course, but the experts have a view about how the particular issues that they're being asked to opine upon impact, given the case theories from both sides. But it does depend on how counsel develop their case.
So I have two full questions. First is that if a party appoints the expert, does the tribunal get a right to cross-examine that expert? And if so, at what stage can the tribunal intervene and cross-examine that expert? And second is, what are the grounds on which we can impeach the credibility of an expert? Can it be on his personal grounds, like moral turpitude, for example, like it happens in civil cases? Can that criteria be followed in international commercial arbitration? Thank you.
Well, those questions are a lecture in themselves. Let me try and briefly answer. The process of engagement between the tribunal and the experts can vary at an evidentiary hearing. Sometimes the experts are first questioned by the tribunal. Now that's hard work for a tribunal because they need to be absolutely on top of what the experts have said and where the areas of difference are. I've had cases where counsel have asked that particular experts be dealt with in that way and have done it. But normally, with common law counsel, the way it evolves is that the experts in each discipline are sat together. They normally make an initial short presentation of why they say there's differences between them each before anyone's crossed. Then the cross-examination starts in the usual way, but the tribunal intervenes during the cross-examination at the end of particular lines of cross-examination to just clarify or ask questions of the expert being crossed. If the issue is a general issue and the counsel agree, then the expert not being cross-examined is asked by the tribunal to comment on the answers given by the expert being crossed. The non-cross-examined expert can't intervene without the tribunal asking. Then at the end of that process, if the tribunal has remaining questions common to both of the experts, they will then ask the experts those questions. But usually, most of the issues have been clarified by tribunal intervention during cross. It's important, though, that tribunals don't take over the cross-examination and don't interrupt a line of cross-examination, but wait till it's appropriate to ask their question. Now, challenging experts. Now, that's a whole area. I do a number of arbitrations in North America. And because of the jury system, there has been developed in North America for experts a concept called a voir dire. You have voir dire in criminal proceedings, perhaps, striking out evidence which perhaps has been improperly obtained or the like. I'm used to it in Australia in the criminal context. When I was at law school, I learned about it. But in America, they have a voir dire on experts every time, which is, you're not an expert, are you? And if you are, you're hopeless. And the submission is, after this preliminary proceeding, that you should strike the expert's evidence, which never happens, of course. It just wastes an enormous amount of time. I like to have the expertise challenged when they're first identified. But that doesn't stop counsel saying, you really don't have as much experience as the other expert, or you don't have experience on a particular aspect. During cross, that's fine. I just think the American system is a waste of time, but they're used to it, so you've got to keep them happy.
So, I have a question for you. So, you're referring to the method of hot tubbing of witnesses, that it is a practice which you appreciate and which you perhaps in your arbitrations accept. So, my question is that for hot tubbing of experts, the arbitrator needs to be extremely familiar and very comfortable with the issues, underlying issues in the matter, which we see to probe the expert critically, which these days we see in a lot of arbitrations, the tribunal is not actually comfortable with the kind of issues, the areas of expertise on which the expert give their evidence. So don't you think that it is very important that the arbitrators and lawyers must be familiar with certain areas or increase their comfort with areas like quantum or delay perhaps, or perhaps have an expert on the tribunal itself? So what is your take on that, sir?
It's all a good idea and was mentioned in the introduction.
So Doug, in fact, I would like you to explain to the audience how does it operate on the ground when you have witness conference and hot tubbing. How does it actually operate? You could give us an example?
I think empty only.
Well, you mean how does it physically operate?
Yeah, I mean, you have one witness and you have another witness.
Yes.
And are they made to confront each other on areas which the tribunal sets for? Then you iterate as to what is very relevant to the proceedings, or how do you go about it?
Well, the experts in each discipline sit together on a long table when their evidence starts. I don't like the idea so much of confrontation. I prefer the concept of cooperation between the experts. I think psychologically, one of the great values of having them sitting together separate from counsel at the witness table is that they are able to perceive that their role is to assist the tribunal, not to make the bullets for counsel to fire. So counsel have to be fully prepared. They don't have the expert sitting beside them giving them the questions to ask. They have to do it by themselves, so the experts are there separated from counsel. Usually, but not always, the first explains why they have formed a different view to the other on the areas of identified disagreement. Then, cross-examination starts, usually by counsel. As I mentioned, sometimes the tribunal leads the questioning. That is more valuable. Yeah, well, I won't go to legal experts. No, I won't go there. I was going to say it's better for the tribunal to deal with legal experts in my view. It's rare for the tribunal to do the questions. Counsel will start in the order in which you'd normally do it, and then at the end of that line of questioning, the tribunal can ask its own questions. Okay, we're finished with that area. We'd just like to ask you this or this or this. So they'll answer that, and then you might say to the other expert, with counsel's consent, well, what do you say at the answer to that question? And sometimes they agree. Sometimes they agree. Sometimes they don't, and you can get a feeling for exactly what the difference is. And so you move through the issues in that way. And then at the end of the cross, if there are residual questions the tribunal has in their mind, they will then ask both of them those questions, and they'll each answer in turn. They don't cross-examine each other. Very important to avoid that, because I've found that there are some experts who are frustrated advocates, and giving them the chance to do that is not possible.
Good evening, sir. So, it is generally understood that appointing an expert has huge cost implications on the parties. So, I want to ask whether appointing an expert in all arbitrations having technical points is imperative, and whether the same increases the chances of success.
It depends on what the issues in dispute are. If there are technical issues which a party has within its own organisation sole expertise about, then it's necessary for that technical evidence to be given by an employee of the party. That happens a lot more in India than anywhere else in my experience, and diminishes the value of the expertise, because in cases I've had where that has happened, the witness has been more an advocate than an expert, and therefore trying to work out what the real technical position is has been more difficult. There is obviously cost involved in appointing technical experts, and in some arbitrations I've seen the cost of the experts has been higher than the cost of counsel, because some experts command huge fees. So therefore there's a balance to be achieved, And the question really is for parties, how best to inform the tribunal of the technical issue. And in some cases, the position you describe or you have in mind is the only solution, but it's usually a less than satisfactory solution in getting to the bottom of the technical issue. It's cheaper, but doesn't help the tribunal so much.
I have one question, Doctor. It's what I just sort of want to express it. Does it therefore help to have an arbitrator as an expert?
Yes.
Even when you're dealing with an expert with the party who first presented for the session.
Yes and no. The real problem with a true expert on the tribunal is the danger that they don't give the party the opportunity of understanding what's in their head. And therefore, the advocate is disadvantaged because they don't know what that expert is thinking. Now, we all know that due process requires that if a tribunal member has a particular view that might influence the decision, they should articulate that to give the parties a chance to argue that. So sometimes having a real expert on the tribunal can be a difficulty. Broadly speaking, it's a huge advantage. I think it depends on the expertise in question. What is critical is that in the area of the dispute, the arbitrators, if they're lawyers, have experience of the industry. So they understand the sort of issues that are being raised. You mentioned charter parties. That's obviously an area of expertise where shipping lawyers understand the language and understand what they're talking about. In construction-related disputes, I think it is important for arbitrators to understand the industry and understand the sort of issues involved so that they don't have to be completely re-educated. So it's a balance. I think by and large I'd agree that there is a value in having an expert on the tribunal provided they don't dominate the decision making.
Or inject their view to the evidence.
Yes, exactly.
We have time for one last question if anybody has one.
Good evening, Baird. My name is Chaya, and my question is rather a hypothetical situation in which maybe we can explore appointing experts for implementation of awards at the domestic level.
Sorry, I just didn't catch that.
What do you think about the concept of appointing experts for implementation of an award at the domestic level?
For implementation of an award?
Yes.
Well, awards that need implementation are strange animals. So one would need to understand why the award needed to be implemented. I know there are some legal systems, and I'm struggling with an award at the moment where there is a presumption that the remedy for breach of contract, rather than damages, is specific performance, different to the concepts that we common lawyers have of damages usually being the remedy. And in that context of an award for specific performance, I could imagine that there could be some value in the tribunal retaining jurisdiction in relation to that process. But whether it would appoint an expert to do that, I'm not sure. Need to know a little bit more about why you needed the help to answer the question.
Thank you, everyone. Thank you, Professor Jones, for those insightful answers.
Thank you. So I hate going last because there's not much to say really. The topic was very well covered by two esteemed authorities, and the role of expert was discussed in some detail. But I'll take a shot at summarizing what is being said and giving just a brief views of my experience of acting as an expert in some of the arbitrations which were mentioned. Generally, I think the theme was covered well today in the sense that the increasing complexity of disputes, the rise in cross-border investments, and the large sums which are now at play in most arbitrations. The role of experts is in turn increasing. And increasing their role is becoming indispensable for some large-scale arbitration which require very specific technical and quantum expertise. I found this very interesting example online which said the London Court of International Arbitration, or the LCIA, registers some 300 new disputes a year, and the institute, as per the institution, most, if not all, involve use of experts. And I think the experience is perhaps similar at other large institutions, including SIAC, ICC, and AIAC. This was a theme again discussed today. As one might expect, the variety of parties and subject matter at play, experts are often used differently from one case to another. Experts offer the expertise in diverse fields, so it could be sector expertise, for example, oil and gas, biotechnology, or skill expertise, engineering, law, finance, economics, and accountancy. In turn, the questions that are often put to experts vary, and from those relating to how industry works, delay analysis in construction matters, opining on accounting principles, and of course calculating quantum or damages arising from certain alleged breaches. Justice Shakhtar mentioned about the increasing role of experts, which is in turn large part driven by increasing complexity in today's environment. He further elaborated on the provisions that allow courts and tribunals to appoint experts, as an example, Section 26 of the Act. Finally, he also spoke about the processes that allow a more meaningful exchange of information between experts. A theme that came through today was about joint experts meeting and concurrent evidence, or what they also refer to as hot tubbing. Professor Jones elaborated on the role of the experts in arbitration. He discussed the key issues in that role, and especially the difference between civil and common law jurisdictions. And I must confess here, the difference is actually very stark in practice. As an expert, you feel that when you're sitting in a box, and the way the process evolves, depending on which jurisdictions the lawyers come from. He also discussed the guidelines that provide good reference points and soft law for use of experts. Two very famous ones being obviously the IBA rules on taking evidence and the CR protocol. Finally, Professor Jones articulated the case management strategies. He commented on the process of appointing experts, the exchange of information and expert evidence, and the use of that evidence finally in making the award. He also discussed the pitfalls, and two big ones again being ships passing by at night, which simply means the experts are answering very different questions, they are less helpful to a tribunal, and also just not willing to engage with each other, which again results in differences which are then difficult to reconcile. The use of experts in India has traditionally been rather limited. For example, limited to often handwriting experts in courts, and in some cases construction engineers to opine on construction issues. This contrasts with my national experience where experts are almost always engaged on a variety of issues arising in a dispute. While my role has been limited to evaluation of quantum experts, tribunals internationally are very well aware of the different roles they might play, experts might play, and the questions they might answer in an arbitration. The process is more defined, structured, and arbitration awards often, if not always, provide an analysis of the questions answered by the experts. Now, with that said, the theme is changing. India has seen, in my view at least, an encouraging trend of more regular and more effective use of experts in large-scale arbitrations, both in a cross-border setting, but also, to my personal surprise, domestic arbitrations. And this trend is supported by multiple expert firms now having their offices in India. The use of experts, especially in large matters, increasing with both counsel and tribunal very much interested in getting the answer right. This is further evidence with more awards discussing the role of experts and acknowledging their contributions to the award. As closing remarks, my role as an expert in arbitrations suggests three broader themes for ensuring effective and efficient use of experts. This is particularly relevant in my view to India. First, and so that's in fact a question which Tariq answered, is both counsel and arbitrators might benefit from developing familiarity with issues upon which experts are frequently asked to opine on. So particularly quantum issues, which features in a vast majority of cases. Second, experts should ensure that they're prepared to facilitate a conversation, discussion with the tribunal, as well as the opposing experts. So this is something which obviously Professor Jones also mentioned in terms of joint experts meeting or joint expert statements, and also finally hot tubbing and joint witness conferencing during the arbitration. And third and finally, I think this was one of the later slides of Professor Jones' presentation, is to agree on a list of issues at an early stage. This is, in my view, one of the most important aspects of getting the arbitration more right and being more effective in the whole process. With that, I now must give a vote of thanks. I would first like to thank Honorable Justice Shakhtar for a very apt opening to today's proceedings and its knowledgeable views on key issues in arbitration. Professor Jones, whose immense wealth of knowledge is always very useful to all of us. Thank you very much to you both for sharing your views and thoughts on the most interesting topic of international arbitration. Second, I would like to thank, of course, the entire DREx team for, as Professor Jones mentioned, for innovating and creating a platform to facilitate an exchange of knowledge and host esteemed practitioners for such valuable talks. Third, all the institutions and groups that have supported the talk today, thank you for your continuing support. And lastly, but not the least, a very special thanks to Shashank, Divyakant and Prerna for putting this whole talk together and all the hard work that has gone behind the scenes that I've personally witnessed. We look forward to seeing you all at the next DREx talk. Thank you very much again.
For those words. Now, in ending, I would like to invite Mr. Divyakant Dhoti to give a small token of appreciation to Justice Shakhtar. Thank you, Divyakant. Now I would like to invite Mr. Samir Jain to give a token of appreciation to Professor Jones. Thank you for everyone for being here. We would like to now invite everybody to join us for high tea in the ground floor.